All right, good morning, everybody. It is May 12th at 9:03 a.m. and this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval, Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Would the other two commissioners please introduce yourselves for the record?
Sure, Madam Chair. Greg Bloom. I'm the designee of the Commissioner of Public Lands. Thank you.
Madam Chair, I'm Dr. William Ampuma, the designee of the Energy Secretary. Thank you.
Thank you. Also with us today is Florine Davidson, Clerk to the Commission, and Chris Moander, Counsel to the Commission. Commissioners, is there a motion to approve today's agenda?
You are muted.
Thank you. Sorry. Madam Chair, I move to approve the agenda for today's meeting.
Is there a second?
Madam Chair, I do second.
Okay, Mr. Moander, would you do a roll call, please?
Happily, Madam Chair. Dr. Ampoma?
Approved.
Commissioner Bloom?
Approve.
Madam Chair?
Approved.
The vote is unanimous.
Thank you. Next item on the agenda is approval of the April 14th, 2022 meeting minutes. Commissioners, have you reviewed the minutes and is there a motion to adopt them?
Madam Chair, I did review the minutes and I move to approve them.
I second, Madam Chair.
Mr. Moander, would you do a roll call, please?
Yes, Madam Chair. Dr. Ampoma?
Approved.
Commissioner Bloom?
Approve.
Madam Chair?
Approved.
The vote is unanimous.
Thank you. All right, next item on the agenda item number 4 is review and vote on order in case number 22473, which was application of Titus Oil and Gas Production for approval of production allocation. Commissioners, have you reviewed the final order and is there a motion to adopt it?
Madam Chair, I was able to review the final order and I move to adopt it.
Madam Chair, I do second.
All right, would you do a roll call vote, please, Mr. Moander?
Yes, Madam Chair. Dr. Ampoma?
Approved.
Commissioner Bloom?
Approve.
Madam Chair?
Approved.
The motion is unanimous. The vote is unanimous.
All right, thank you. Commissioners, would you, I believe the Commission Clerk, Ms. Davidson, will circulate that order to everybody. If you could please sign it and return it to her. All right, thank you. Next item on the agenda is de novo case number 22474. And it was OCD case number 22294. It was application of COG operating for compulsory pooling. So we heard the testimony from witnesses at our last regularly scheduled meeting on, let's see, April 14th. Council was directed to submit written closing arguments, which both councils did. Just a process question, Mr. Moander. I guess, do we need to provide an opportunity to give any additional verbal statements or not?
That's at the discretion, really at your discretion, but generally the discretion of the commission. Since you did instruct parties to submit written closings, which they did, that would seem to wrap up the case. But if the commission would like to hear more from the parties, the commission's free to do so.
Okay.
Or not.
Great. How about for the council, Ms. Hardy and Mr. Tremaine, you can give a brief verbal argument. I would say, really no longer probably than 5 minutes, because the commissioners have reviewed your written testimony, not testimony, your written closing statements. But Ms. Hardy, if you would like to begin.
Sure. Thank you, Madam Chair. And I will be brief. I think that our written closing addresses the issues raised by OCD. One of the primary issues is that OCD is relying on the provision of the Oil and Gas Act regarding proration units. And we've discussed in our written closing the fact that the New Mexico Supreme Court has held that that provision does not apply to spacing units. They're different concepts. And that's in the Rudder case from 1975. And the division codified that decision of Rudder in its amendments that were adopted to the horizontal well rule in 2018. And we've cited that provision in our brief, and it is the definition of a spacing unit, which specifically states that under the Oil and Gas Act, paragraph 1 of subsection B of section 70-2-12, and that's the provision that OCD is relying on, the division's regulation states that the commission may fix spacing units without first creating proration units. So I think it's clear that the OCD's argument based on that provision of the statute is incorrect. I think the second main issue that's addressed by our closing is that when you interpret the Oil and Gas Act in conjunction with the division's regulations, and that is how the regulations have to be construed, the division and the commission have to consider the act, the definition of a proximity tract spacing unit, which refers to the horizontal oil well, has to be construed to prevent waste and protect correlative rights. And when that is done, COG's proposed spacing unit and interpretation of the rule makes the most sense, and it's consistent with the requirements of the act. And I think that OCD's argument ignores that fact and really focuses on sort of a narrow construction of the rule that's inconsistent with the act and the remainder of the rule. COG's proposed interpretation is most consistent here with the protection of correlative rights and the prevention of waste. And our evidence, I think, supports that, as well as the law. So I think that's all that I have, unless there are questions. Thank you.
Thank you, Ms. Hardy. Mr. Tremaine, do you have any closing statements?
I will be very brief, Madam Chair. The Oil Conservation Division would limit his comments today, again, relying on the closing argument to respond to a couple of specific points. OCD's interpretation of the Oil and Gas Act, I understand the case referenced by Ms. Hardy. That case does predate the current version of the statute, and OCD does not dispute that proration units and spacing units are distinguishable. However, for the purposes of identifying the limits to spacing units, OCD refers to these reference sections of statute because there is not otherwise guidance within the statute. We think that that argument holds, and that there is a clear legislative limit on the extent of quote unquote standard horizontal spacing units. However, the interpretation of the statute is half of the discussion. The rule itself is unambiguous, and it speaks to the definition of standard horizontal spacing units as those for both oil and gas wells, as those areas, tracts that are penetrated and defined by a single well. Arguing that there are other sections of both the statute or rules that could lend themselves to a different interpretation, I think is I think is inappropriate because those sections do not have to be read as COG argues in conflict with the plain language of the rule. That definition is again unambiguous, and that rule was promulgated by this commission after public hearing, and regardless of any differences of opinion regarding the statutory interpretation, that rule is an independent reason for the commission to rule in the division's favor. There is nothing in the record that I can identify that says that the rule itself is in any way in conflict or violating the statutory limits. The rule was promulgated appropriately and within the appropriate purview of, in terms of procedure and in terms of the purview of this commission. The argument would be different if COG were arguing there was some facial flaw or procedural flaw in the promulgation of that rule, and then we'd have to go back and look at that statute. But the last point, Madam Chair, the one moment. Oh, excuse me. The COG relies upon sections in the statute about correlative rights and prevention of waste. I think it was clear from the hearing and testimony at the hearing and COG's argument that COG may choose to respond to a ruling in the division's favor by modifying their development plan. But that a change in that development plan would not be required if the commission rules in the division's favor. So this argument that ruling consistent with the division's interpretation would impact correlative rights or result in waste is a straw man, and I don't think that the commission should be moved by that. There are certainly implications for COG that they need to consider in terms of business risks, but there's nothing about the commission making the decision that standard spacing units are limited to being defined by single wells that would require COG to proceed in a different manner than they have proposed. It just means that COG has to proceed with their applications and notice requirements in conformity with the rule. And with that, I would rest. Thank you, Madam Chair.
Thank you, Mr. Tremaine. All right. I think that Mr. Moiner, at this point, can we close the record?
Well, actually, Madam Chair, you probably closed the evidentiary record after the evidence. So you asking just close the record in total at this point?
Yes.
Yes, you absolutely may.
All right. So the record of this hearing is now closed. The commission may immediately deliberate to reach a final decision on this. I would move that the meeting be closed pursuant to the Administrative Adjudicatory Deliberations exception to the Open Meetings Act, Section 10-15-1H3, to deliberate in this case. Is there a second?
Madam Chair, I so second.
Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Dr. Mpoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
Madam Chair, the motion carries.
Thank you. The commission will now close the session and the record. For process purposes, so commissioners, I set up another link. So if you want to join that and switch over, I will keep this running for everybody else. And let's plan on, I don't know how long this will take, but why don't we plan on checking back at 10 o'clock? And I will give everybody an update as to whether the commissioners need additional time or if we will be coming back at 10 o'clock. So everybody can hang tight on here until 10 and I'll give an update at 10.
Okay.
Thank you.
Thank you. All right, welcome back. It's 10 o'clock and we will get started again. Is there a motion that the meeting be opened? And that, I'm sorry, the words. Is there a motion that the meeting be opened after being closed pursuant to the Administrative Adjudicatory Deliberations exception to the Open Meetings Act, Section 10-15-1 H3, and that the only items were discussed during this time were in relation to case number 22474.
Chair, I so move.
Madam Chair, I
Second.
second.
Thank you. Mr. Molinder, would you do a roll call vote, please?
Yes, Madam Chair. Dr. Impoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, thank you. So the meeting is now open again. All right, in case number 22474, is there a motion, or I'm sorry, I make a motion that the commission finds that the order number R21930 and division case number 22294 is valid and the commission upholds and it readopts the order. The regulations are straightforward and they communicate what is required by the operator. The commission does not find any conflict between the regulations and the Oil and Gas Act. And the commission recognizes and applies waste and correlative rights. And the commission does not find that the division order violated those principles. Is there a second?
Madam Chair, I second.
Is there any discussion before we do a roll call vote?
No, Madam Chair.
No, Madam Chair.
Okay. Mr. Molinder, would you please do a roll call vote?
Yes, Madam Chair. Dr. Impoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries. I should be able to, consistent with prior practice, get an order drafted and submitted for the next meeting.
Okay, and we can finalize that at the next regularly scheduled meeting on June 9th. All right, Mr. Molinder, are there any updates on pending litigation?
Well, I'm starting to sound like a broken record at this point, but in case A1CA 39578, we're still awaiting action by the Court of Appeals. I took a look this morning. The court there's nothing that's gone on since mid-February. There was just some filings by counsel swapping out attorneys. So we're still waiting.
Okay. Is there any other business? All right, the next meeting is a special meeting on June 3rd. And then we have our regularly scheduled meeting on June 9th. And with that, it is 10:06 a.m. Thank you, everybody. We will close the meeting.
Thank you all.
Have a good rest of the day, everyone.
Thank you. Bye.